Or a big budget movie that's fun and silly and
And
profoundly
emotional.
emotional, impactful, like Deadpool,
Deadpool,
Wolverine in
Wolverine.
theaters now.
Yes, yes.
I'm working double time, you guys.
Yeah.
I'm double duty.
It's just the best. It's the best. I love it.
Answer, be a fan, watch movies. Like, you will learn so much from watching movies. Watch movie like it's your job. Story, like, you learn by watching movies. When people tell stories, you learn how to tell stories. And like,
Hey besties, welcome back to my channel. The New York Times is playing a game in the media. And it's wild to say that because growing up, to me, the New York Times was sort of the benchmark of what the news was. You know, if it was in the New York Times, it must be true. We've learned over the years that, no outlet, no media outlet is without error. And sometimes outlets get stories outright false. But there's also a really high bar that you have to cross in order to be able to successfully sue a journalist. And listen, these are good. It's good that we have these laws because the worst thing that can happen in society is the suppression of freedom of speech and freedom of the press. In the case between Baldoni and the New York Times, he sued them for reporting on the CRD document that Blake Lively filed in the state of California. Because New York fair reporting privilege allows for the reporting on on documents filed with the government, even if they're confidential or they haven't been publicly released, they were able to report on this confidential CRD that Blake Lively now claims is confidential under the protective order. Okay. So they sought a couple weeks ago they asked the judge, they want to have a rule for a final judgment. They're asking the court, we want a final judgment in this case because if we get a final judgment, then Mr. Baldoni can appeal. And if the appeal goes through, we can start discovery. And if the appeal does not go through, then we can be done and this case can be over. But we don't want to be a part of this case anymore. When they filed that, Wayfair has 3 weeks to respond, which means they have to respond, I believe, maybe tomorrow or Monday. So Wayfair's response to this is upcoming. To date, the judge has not issued a final judgment. Okay. So until a final judgment is ordered, they cannot ask for attorney's fees and they really are not out of the case. And they also cannot, the case cannot be appealed. But that hasn't stopped them from trying to go to the state to file what looks like a lawsuit. But while the media that obviously received this, whether it was from the court or directly from the New York Times, a document is being shopped around that actually has not been accepted by the clerk. It looks like a lawsuit, but the index number is unassigned and it actually has a warning sign on it. It says this document has not been reviewed by the court. Caution, caution. Readers should be aware that documents bearing this legend may not have been accepted for filing by the county clerk. And because of the law, the county clerk can actually reject this. Now, what is interesting about this is that the New York Times is trying to, instead of get attorney's fees from the federal court, from the judge in the federal case, they're going to the state court and they're suing under violation of civil rights law 70A, 76A. The Times repeats and realleges and reincorporates the allegations in the foregoing paragraphs that New York's anti-Slapp law provides that in an action involving public petition and participation in prevailing defendant shall recover damages, including costs and attorney's fees from any person who commenced or continued such action. Costs and attorney's fees shall be recovered upon a demonstration that the action was commenced or continued without a substantial basis in fact and law and could not be supported by substantial argument for the extension, modification, or reversal of existing law. The lawsuit against the Times was an action involving public petition and participation under New York civil rights law. It was based on a new news article published by the Times, communications in a public forum in connection with an issue of public interest, and lawful conduct in the furtherance of the exercise of the constitutional right of free speech in connection with the issue of public interest. The district court's opinion makes clear that Wayfair and its affiliates both commenced and continued this lawsuit against the Times without a substantial basis in fact and law. Under such circumstances, New York's anti-SLAPP requires that the Times be awarded its costs and attorney's fees and such other compensatory damages as the court deems just and proper. So, when they asked the court for these fees, what they told them is that the district court dismissed the claims against the Times and that the district court found, to the extent they fell outside the privilege because they relied upon communications not included in the CRD complaint, they were not plausibly made with actual malice. The district court specifically noted that the CRD complaint and article contained numerous messages and documents strongly suggesting the Wayfair parties did spread negative stories about Lively, and that a reader of the messages would have little doubt that Wayfair parties engaged in a smear campaign. The district court rejected the idea that actual malice was established by certain text messages that the Times allegedly saw and suggested that the negative publicity about Lively was coming from sources other than Baldoni and his associates. Those texts did not overcome the reasonable inference to be drawn from the text indicating there was a smear campaign, even if others on their own attacked Lively online. The district court noted that the article's inclusion of additional context favoring Baldoni and the prominent incorporation of the plaintiff's denials cut against an inference of actual malice. In sum, the amended complaint failed to adequately plead multiple necessary elements defamation claim. The New York court dismissed the false light claim because the state does not recognize that. And the district court dismissed the promissory fraud and breach of implied contract, holding that they were meritless. The district court found that no contract existed and that the email at most was a promise that Wayfair and its affiliates had until noon to provide comment on reporting. The Times incurred not less than $150,000 in legal fees and costs for defending the claims. So what they're saying is that because all they were doing was reporting on matters of public interest and they were reporting on this legal document, and even though they relied on these texts, they also gave a more favorable arc to Baldoni in this article, and they also allowed Baldoni to respond that there was no actual malice by the New York Times, and so thus it would fall under this law where you can get attorney's fees under New York anti-SLAPP law. So I'm all about freedom of the press and freedom of speech, but I've said from the day one, I never really understood this point of going after the New York Times simply because it's almost impossible to beat them. And it almost just felt like a PR move because they knew that they weren't going to win. I know that there's people that strongly believe that they could have a case, and there is some questions about whether or not using the other text messages going out of what the document said that was filed with the CRD, whether or not they properly and accurately portrayed the CRD complaint as a complaint, a CRD complaint, and not a lawsuit. Those are questions that if Wayfair wanted to appeal, they could. But what this lawsuit is sort of, to me, kind of gamesmanship is that one, it's being put out to the media as though it's a lawsuit and it hasn't been accepted in the court. Two, it's being filed in a New York state court, which is really questionable because it would appear that they're going to the state because they want a more favorable outcome, which actually looks like forum shopping to me. Because in federal court, the Southern District of New York has often held that this anti-SLAPP statute is not applicable in federal court. They generally do not award fees under these anti-SLAPP provisions in New York Southern District of the Second Circuit, right? The appropriate place for this would be to be filed as a separate motion under the rules of civil procedure in federal court. And the appropriate time for them to seek these attorney's fee would be after the judge issues the final judgment, which he has not yet done. Another issue here is that it's risky for them to file this in state court because Justin has grounds and Wayfair have grounds to remove it from state court and bring it back to the district court and have it assigned to Judge Lyman. So because this case originates in federal court, there's a relatedness, right, between the federal case and this request for attorney's fees. And the original dismissal did not occur in the state court. So there's a rule, it's under 28 USC 1441, and a defendant can remove a case filed in state court to federal court if the case could have been brought there originally And then under this Rule 28 USC 1367, the federal courts also have supplemental jurisdictions over claims related to an action already decided in federal court. And it's really all it is a state claim going to a New York state court for a claim for attorney's fees arising from a federal case. So this actually belongs in federal court with Judge Lyman. So all he would have to do is file a notice of removal, and the federal judge can say, this really is a post-judgment fee dispute from my case, and it belongs back here. And he already said that Reynolds and Lively and Sloan could seek attorney's fees through a separate motion. So it just begs the question why the New York Times goes to state court. And once it's removed and it's brought to federal court, the judge can actually deny it under Rule 54, or he could maybe apply it narrowly, but that's probably not what they want. So technically, once your case is dismissed, you usually are supposed to file a motion for attorney's fees within 2 weeks after the dismissal. It could be also after final judgment. So if they get a final judgment and if the judge awards a final judgment, they could also get attorney's fees there. But they should have filed for the attorney's fees 2 weeks after the case was dismissed. And by going to a state court, it almost feels like they know that if they were to ask for this in federal court, they might lose. And if they go to the state court and they file this in state court and then it's removed to the federal court, it honestly just looks like they did it for a forum and that they wasted resources, they wasted time. They're just incurring more attorney's fees by going that route. And it would seem like they are going the state route because they feel like they know in the federal court they would lose. And it's super hard to figure out and pin down what the federal court in New York feels and how they feel about the anti-SLAPP laws. They changed provisions of the anti-SLAPP law in New York in 2020. And there's aspects of it that judges have ruled are not permitted because they conflict with the civil rules of procedure in federal court. And then there's other judges that have said the fee shifting is allowed. And even with the fee shifting, they will award some damages or attorney's fees, not damages. So some judges are inclined to award fees, others are not. Others hold to the fact that these rules of these SLAPP lawsuits conflict with our rules in the court. So it's a gamble to ask for the fees to begin with, and it's always a gamble because as the defendant, you are going to the court asking for it, arguing, and Wayfair is just going to come back with their own argument about why it's not permitted. And then it's up to the judge to decide whether or not he agrees that it's not permitted. And I did a search from a case that Judge Lyman was involved in, and it was Griffle's essay versus you, and he denied a motion for anti-SLAPP fees. His decision stated that defendant's motion for fees pursuant to New York Civil Rights 70A must be denied. Docket number 45, section 70A states that a defendant in an action involving public petition and participation may recover attorney's fees upon a demonstration that the action involving public petition and participation was commenced for continued without a substantial basis in fact or law. So this is what the New York Times is trying to tell the state court, is that they continued this without substantial basis in fact or the law. So his argument for that case was that the plaintiffs disclosed the Scranton loan in financial filings, and the report, after having reviewed those filings, stated multiple times that plaintiffs did not do so. This provides a substantial basis for plaintiffs to commence this action. Because the motion for anti-SLAPP fees must be denied in any case, the court need not address the plaintiff's arguments that such motion cannot be properly brought in federal court. The New York Times is telling a state court through this filing that, again, hasn't been accepted by the clerk, that the judge ruled that the case was meritless. But he actually didn't rule that the case was meritless. And when the lawsuit was dismissed, he denied anti-SLAPP for Leslie Sloan and for Ryan Reynolds with an option for renewal if further information was discovered that would prove that it was brought without merit. He's already made the decision not to award fees multiple times in this case, and he avoided making a decision completely on the SLAPP. It's very similar to him not taking a stand on 47.1, instead relying on fair report privilege or not meeting the bar of actual malice. So his actual grounds for dismissing it was much of the reporting was protected by fair report privilege, and the plaintiffs didn't plausibly plead actual malice. None of that actually states that they didn't have grounds or that they didn't have a reasonable basis for the lawsuit or a substantial basis. He made no decision on it, and he doesn't like to make those decisions if he doesn't have to. I mean, with the other case, he just said these fees wouldn't be awarded anyway, regardless. So I'm not even going to decide if I have to award these on the federal law. And here he's saying, I'm dismissing it on these. So I didn't even have to decide if anti-SLAPP was the appropriate mechanism. He's like taking the path of least resistance to avoid awarding fees. And he might just be one of those judges that doesn't award attorney's fees unless it's an egregious case, right? So this could be why they're going to the state court and why they're avoiding Judge Lyman. It's all just totally premature. And I don't really know what's going to happen. I just know that in Lyman's history, he doesn't seem to like to award attorney's fees. I don't know if Wayfair's planning to appeal. They have hired appeals attorneys. I don't know how successful an appeal would be. Again, it's a very high standard you have to meet in order to sue the New York Times or really any news outlet. Even if we agree that what they published wasn't nice and that they used a CRD complaint and they misrepresented that it was a lawsuit when it wasn't, those are such small issues that at the end of the day, she ended up filing the lawsuit. So does it really meet that it was malicious? I really don't know. And the court in New York said no. And until an appeals court looks at it, we really don't know. And we don't even know if Wayfair is going to appeal. We know that they have appeals attorneys. We just don't know if they're going to appeal. But currently, the lawsuit is not yet filed. And the appropriate place would be to go to federal court. And they aren't going to federal court. And even if it is filed in the state court, all Justin and Wayfair have to do is bring it back to Judge Lyman and let him make the decision. So it's really a strategic legal strategy that's probably going to blow up in the New York Times faces on that side. And it's probably that they may not get awarded fees. So, what are your thoughts about it? There's a lot of competing lawsuits going on. There's a lot of thoughts about the New York Times. I'm trying to stay at best neutral on that. But what are your thoughts about them asking for attorney's fees? And what are your thoughts about them going to state court? That's what I don't like. That's what I don't like. Do you, or does it make sense to you? Tell me your thoughts in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and please click the bell so you never miss a video. Thanks so much for watching. Bye, besties.